Good morning and welcome. My name is Frank Motley. I'm Assistant Dean for Admissions for the law school, and it is my name at the end of the letter that you received admitting you to the law school. On behalf of the faculty and staff of the law school, I'm honored to be one of the first to extend a heartfelt welcome to you. We are glad you're here. Before I say more, I need to do some thank yous, and one of the most important thank you is to Janet Hein, the Director of Admissions here at the law school. She is primarily responsible for the logistics of the day, the correspondence you've received, and selecting some of the best students to be fellows, whom some of you have met already today. So I'd like to thank Janet particularly for all her work today. I also want to ask you, Chris Ford, who's Director of Operations, Jennifer Davis, and Maurer Bernstein are staff here in the admissions office, and some of you have had contact with them. They do a great job, and they would really appreciate your saying, I would appreciate your saying something to them if you've been helped by them in this process, but they've helped make the trains run, and I really appreciate it. So if you could say something to Maurer and Jennifer and Chris, I really appreciate that. These are exciting and difficult times. You are about to make a major commitment of your time and family resources. It is important and appropriate for you to explore the places to begin your study of law. We are glad you're here with us today to get a closer look at the law school. A law school is more than bricks and mortar. It is the people that inhabit the building. It is the learning that transpires and the lasting friendships that are formed. It is a community that you will choose to be part of for the next 3 years. In the next few hours, I hope you will take advantage of the opportunity to meet faculty, staff, alumni, and fellow students. Most importantly, I hope that you get to meet each other, your future classmates. You are truly remarkable people, and I know that because I've read your files. I will be around all day. I hope you have an opportunity to talk with, I hope I have an opportunity to talk with you if you have questions or concerns. But this morning, before I sit down, I have just two other things to do. One is to indulge in some morning calisthenics. That means I'm going to ask you to get up for a few seconds. And the other is to introduce the dean. The morning calisthenics consists of this, is to ask you if you fit this category to stand, so we get to know a little bit about each other. We can't go around and do introductions unless you insist. I assume you won't. But if you grew up west of the Mississippi, please stand. Okay, thank you. If you worked full-time after graduation from college, please stand. Okay, and if you have studied abroad, please stand. Somebody's been standing all day or something. Okay, if you have done the AmeriCorps, Teach for AmeriCorps, Peace Corps, please stand. Okay. If you served in the military, full-time or reserves, please stand. If you have a Bachelor of Science versus a Bachelor of Arts, if you have a Bachelor of Science, please stand. Okay, thank you. If you have an advanced degree beyond the bachelor's, an MA or a PhD, please stand. If you've played varsity sports in college, please stand. And just 3 more. If you were on the debate team in college, please stand. Okay, great. And if you majored in political science, please stand. Okay, and if you didn't major in political science, please stand. Okay, thank you very much, appreciate it. But hopefully you get a chance to have something in common with your fellow classmates and you'll follow this up. And now it's my pleasure and honor to introduce to you someone who is truly remarkable, someone who cares deeply about the law school and the quality of your education. He holds the James H. Rudy Chair and teaches civil procedure, constitutional law, international and environmental law, and is perhaps the only person who is happier to see you here, and this is the Dean of the Law School, Austen Parrish.
Thanks for that. Normally you wait to hear what I say before you clap, so I appreciate that enthusiasm. Look, it's wonderful to have you here, and it's been really nice to get to know a lot of you guys. I know I've met a bunch of you before you came in receptions and in mock classes during the past year. And as accomplished as all of you are, I think I learned last night, at least, that you're crappy bowlers. At least that's the rumor that's on the street. So thankfully, we don't have to worry about that. Well, look, I'm incredibly proud to be the dean of this school because I think there's something special about IU Bloomington. I could go on about the particular programs. I think we have a particular expertise in some areas that other schools don't, in cybersecurity, intellectual property, constitutional design, and tax, environmental, and whatnot, and goes on. But I think really what distinguishes us is there's something unique about each school, about its place and its culture, and I like our culture here. I think it's a particularly warm place. The faculty are open and interact with students all the time. But what I really like about it is I think not only do we have a strong educational program where students do interesting things to learn how to be good lawyers and good leaders, but they also make a difference in the lives of people here in Indiana and also in the world and in the nation in a particularly important way. And so if I just look back at things that have happened in the last couple of months, I look at students that are working with our Center on Constitutional Democracy. Those are JD students that are working on peace reform movements in post-conflict zones, like places like Burma and Libya and Liberia and South Sudan. That's important work, and those people are learning tremendous skills on how to be a lawyer and how to work with clients and how to draft constitutions, which is incredibly important, but they're also making a difference and an impact. That's true not only on the global stage like that. Our Stewart Fellows programs, we now send first-year students around the world. Last year we had about 25 students on full-fledged scholarships in the summer to go to Japan and Korea and Brazil and Argentina and China and Taiwan and a number of other, India and a number of other places where they work with corporations and with law firms and nonprofit organizations doing real work to help people out in the world. And that makes a big difference as well. In Brazil, we've got this great program where people spend 4 weeks at Votorantim, which is a very, very large corporation, and 4 weeks at Demarest, which is a large law firm down there, and then they switch, which is a great experience for a first-year student. But not only do we do that on international, students have an impact right here in the community with places like our Family Law Clinic, Mediation Clinic, our Entrepreneurial Law Clinic, our Intellectual Property Law Clinic. And I think that's important. I think it's important that students are not only learning how to be great lawyers, but they're also learning how to make a difference in the communities they serve. Because one of the differences, I think, between a great lawyer and a mediocre lawyer is somebody that is a leader in their particular community. That could be that they're serving on the PTA, or that could be that they're running for a political office. But they're doing something important to make a difference in society in many different ways. And we have a history of that here. And that warms my soul as a dean to know that we've got that background. Anyway, so I'm incredibly excited because I think I've read many of your files too, and I think you have a lot of the same sort of characters and traits that a lot of our most successful grads do. And so I'm glad you're here. Hopefully what you're doing is you're getting a sense of whether this is a good fit for you. And if it's not, you should go somewhere else. And if it is, you should stay here. And we'd be excited to have you. Let me, you don't want to hear from me, and we've got professors that are going to talk, give you much more information about the school. But let me put out this offer. I am happy to talk to any of you, anytime, about the school. So if you want to speak with me, it's easiest to send me an email. Send me an email, we'll have a conversation. Normally I'm pretty quick on email. You can look me up on the webpage, I'm sure you can figure that out. So type in Dean, IU Maurer, I'm sure you can find me. Go ahead, just say you were here in the classroom, happy to talk to you at any time. The other thing is, I'm happy, don't tell faculty I told you this, I'm also happy to connect you with any faculty member on any other subject matter that you're interested in. So if you're sitting here and you're like Palmer here who says, I want to do water law, that's my area of expertise, that's what I'm interested in, I'm happy to connect you to an environmental professor or a professor doing water law. You say you want to do women's rights issues, you want to do civil rights law, you let me know and I'll put you in contact with faculty that work in that area. Now I'd recommend you do that if you're interested, because I think what you should be getting a sense of is who are the mentors and the role models that are people that are going to be nurturing you and sponsoring you while you're here in law school. And getting a sense of who the people are you're going to be interacting with. So if you'd like that, and no pressure, you don't have to, but if you'd like to be connected with somebody substantively in your area, the admissions office can do it, but I'm also happy to make that introduction to you as well. You just need to email me. Offer to anybody who's interested, just feel free. Anyway, look, really nice meeting you. I hope we, don't break my heart. I hope I see you guys in the fall, now that I've spent all this time getting to know you. And I hope I see you in the events in the next couple of days, and I hope you have a great spring law day. Thanks for coming out. I think it's a great way to get to know the school. Thanks so much.
You all are probably going to get sick of seeing me, but again, I'm Janet Hein, so welcome. I think I've welcomed many of you already today. But I just wanted to make a couple of very quick announcements, kind of logistical things. First of all, in this corner of the building, the all-important restrooms, they're on every floor, and there's drinking fountains like right around the corner on every floor. Also, in your packet, there is a list of all the participants and what lunchroom you will be in today. And we've done that for a reason. We're trying to connect you up with the fellows who have already talked to you. There's also a list of those out on the agenda board so you can see what lunchroom you're in. We also have indicated on there at the end of the day what student panel room you are in as well. And then for the alumni event, alumni networking event that's a little bit later this morning, that will be in the library, which is down the hall. But please know there's alumni in sort of the pit level of the library, entrance level, and one level above. So make sure you look and see which alumni are where. That alumni list is also in your packet, and there's a map on the reverse side that'll tell you where those alumni will be if you want to zero in on somebody in particular. That's really all I wanted to tell you. I'm actually going to introduce our next speakers, who I think you'll really enjoy. We have with us this morning Associate Professor Ryan Scott. And Professor Scott got his bachelor's at Macalester College in St. Paul, Minnesota, and JD at University of Minnesota Law School. We also have with us today Professor Victor Quintanilla. And Professor Quintanilla got his undergraduate at University of Texas at Austin, master's at University of Texas at Austin, and JD at Georgetown. So I'm very happy to introduce them to tell you a little bit about a first-year class and class preview. So Professor Scott, I think you're first.
Thanks very much. Good morning and welcome. My name is Ryan Scott. I teach criminal law and criminal procedure here at the law school. I used to work at the Department of Justice. I was in the Solicitor General's office for a while. And I've been teaching here for 6 years, and I had never been to Indiana before I interviewed for this job. And I have totally fallen in love with this place. I love Bloomington. I love this law school. I hope that you can get a sense of what a terrific place this is. Although you're only going to be here for a day, it sure worked for me. So welcome. We're pleased to have you here, and I hope you take advantage of the chance to meet a lot of the student organizations and to get to know some of the faculty. You've got in your packets some hypotheticals, some sentencing hypotheticals. These are cases, real cases, that I use in my first year criminal law class. We're going to have a little mock criminal law class. My research, among other things, focuses on criminal sentencing. And so we're going to do a couple of sentencing hypotheticals and get your sense that you're going to be judges today. You're going to decide, if you were the judge in these cases, what kind of sentence do you think is appropriate? And we'll have a discussion about why you think that sort of sentence is right. Let's start with the first hypothetical. It's a firearms offense. Gil is a professional basketball player in a major U.S. city, let's call it Washington, D.C. He brought 4 unloaded guns into a locker room at the team where he works and puts them on a chair next to his teammate's locker with a sign that says, "Pick one." It's a joke. He's not really planning on having a gun battle with his teammate. The teammate recognizes it's a joke. They have a good laugh. The police are not amused. When they find out about this incident, they immediately investigate and prosecute him for possession of an unlicensed firearm. Initially, he lies to the police. He makes up an implausible story about how the guns weren't his. Eventually, he admits they were his guns. Gil has a long history of charitable work in the city. He's highly compensated as a professional athlete, and he's generous with his money. He gives money to different charities, including organizations dedicated to children's health in the District of Columbia. He also has 1 prior conviction. He's done this before. 6 years ago, he was convicted for carrying a concealed firearm, but that's all of his criminal history. He's charged with possessing a firearm without a license. The statute provides for a prison sentence of up to 5 years, but the judge has discretion to impose a sentence of probation, a non-custodial sentence, if the judge wishes. There are advisory sentencing guidelines in this jurisdiction. So these are just suggestions, they're advice, but they suggest for a person who's committed this offense with this kind of criminal history, a sentence of 6 months to 2 years of imprisonment. Let's, by a show of hands, let's start with, I'll ask the different sentencing ranges, just your intuitions about what the right level of punishment. Let's start with, how many people think he shouldn't be punished as a criminal at all? That this shouldn't be a criminal offense, no punishment, no criminal punishment is warranted. How many, by a show of hands? A handful. Okay, how many would say a criminal sentence, but a sentence of probation, non-custodial, no jail time, no prison time? Well, most of you are in this category. Okay, how about a prison sentence, but of 1 year or less, a short prison sentence? Okay, a few. And how about more than that? Anything more than that? 1 year to 5 years, up to the maximum. Just a couple. Let's start with folks who would have chosen a prison sentence, a sentence of any kind of prison time. What persuades you that that's the right kind of sentence here, as opposed to a lesser sentence? Yes?
First off, it's a repeat offender. The fact that he's done it before, that's why he wasn't sealed the last time, but he doesn't want to get a license.
What is it about the prior conviction that convinces you that warrants prison time this time around?
Even though he's, charitable work and all this other things, clearly he still doesn't have respect for getting a license and doing it properly. It's also that it's 4 weapons. It's not just one for self-defense, it's 4. No one needs 4 weapons for self-defense.
No, it certainly doesn't need to leave them around sitting on a chair for self-defense. Okay, so the fact that he's got a prior conviction means he doesn't respect the law. This sends a signal that he's sort of thumbing his nose at the requirement of getting a registration for his weapon. Okay, so that's one line of argument. Other arguments for a prison sentence? Yes, in the back.
Additionally, assuming he's a basketball player who's making a lot of money, he's probably somewhat public.
Yeah.
And if it gets out that just because you have money, you can just leave 4 guns lying around or just treat them irresponsibly, that creates creates an atmosphere where people think it's okay to do so. And the fact is that usually these punitive damages aren't just to discourage that particular person, but they're supposed to discourage anyone from breaking the laws.
All right, you're making an argument from general deterrence. One of the purposes of criminal punishment is to deter others from committing criminal violations. And maybe this case is the kind where there's actually real bang for the buck as far as deterrence goes. Most criminal sentences fly under the radar. Nobody notices every sentence in a criminal case. But when a professional basketball player is sentenced for a crime, everybody pays. If this is on Sports Center for 2 weeks straight, they're talking about this sentence. That's what's really happened in this case. So there's a value to making a prison sentence here as a statement that you can't get away with this, and we shouldn't treat him in a special way because of his job and the money that he makes. Okay, great. Other arguments in favor of a prison sentence? Yes, in the back.
Going off both of those, if you really want to, at the end of the day, not have that person go to prison, you can, at the end of the day, suspend the sentence as well. So, after setting an example that you will not be able to get away with it, despite having a lot of money and being a role model and having that status in society, you can still suspend the sentence.
Yeah, okay, a suspended sentence operates much in the same way that a sentence of probation does, but it's the judge formally imposes a sentence of prison time, but then suspends it, and as long as you keep your nose clean, don't commit any violations of the terms of your release, then you won't have to serve the time. So that's another option for those who are persuaded a prison sentence is unwarranted. I'll hear one more from somebody who thinks a prison sentence is warranted. Yes, down
And also
front.
just like setting a precedent. I mean, if he can leave 4 guns in a locker room, which is a public space, it's private to the team, but it's also a public space. Where else can you leave 4 guns? Does it go to schools then? Or you can leave it in that school locker room, so just setting a precedent with what you were saying is exactly right. You don't want to have it be anywhere else.
Okay, great. This is dangerous behavior. Leaving 4 guns sitting around, anybody could have picked them up. You're quite right. It's not exactly a public space. Not just anyone can walk into the locker room of a professional team, but lots of people can. People who are on staff, other teammates. There's a lot of people who can go in and out of that space. There's a high probability that those might get stolen or used for purposes of gun violence. And I saw one more hand. Yeah.
I think the analogy to speeding is helpful here. I speed pretty much every day.
Yeah, we all do.
And I've only gotten 2 tickets in my life, so I'm breaking the law constantly. So this man who's twice been, involved with guns, I have a strong suspicion that this might be happening more often than just a couple of times. You don't just sort of stumble upon speeding and get pulled over that one time.
Yeah.
So I have a feeling that sentence might deter him. He deserves punishment because there was a lot of this crime.
Okay, now you're talking about individual deterrence. You're talking about sort of specific deterrence, what's sometimes called. Let's deter him from committing this crime in the future. And the fact that he has multiple convictions, you're saying, suggests that he probably does this more often. And
He's been caught.
yeah, this is the second time he's got caught. We need to use this moment as a teachable moment for him. We need to send a message to the offender. Okay, let's switch it around. Those who would have recommended either no punishment or a sentence of probation, what arguments persuade you that kind of sentence is appropriate? Yeah.
I feel that probation is appropriate through the courts.
because he lied about it, which meant he knew it was wrong.
Yeah.
But then the guns were unloaded, but then he has a prior, but this wasn't an option. But I feel like repercussions through the team would be more appropriate, I feel, because criminally, yes, he had unregistered, unarmed weapons. So, and then he lied to the police, which is obviously fine. But I feel like if he's punished through his team, that might mean more to him than, because he didn't care about lying to the police. He probably came clean because he was going to get caught anyway.
Yeah.
So I feel like that wasn't his filter. So if you punish him through his team, that might affect him more than sending him to jail.
So I like this argument, and it's true. The team was furious with him. They imposed some internal disciplinary, but also his contract was in jeopardy after this. I mean, this is a convicted criminal, and the next team that's thinking about hiring this basketball player is going to offer a lot less money because they're now worried that at any time he might commit a crime that takes him out of commission for some number of years. If he goes to prison for 5 years, good grief, basketball players' careers don't last forever. This could be the end of his career. So maybe maybe a probationary sentence is enough, because this is going to send a very strong signal to someone who has lots of incentives going forward to behave differently. Okay, other arguments for a probationary sentence or no sentence at all?
I think probation would be appropriate because he's doing a lot of good in the community, and possibly adding like a sort of charity work element where he goes to educate small classrooms and teaches them about gun violence, and that could maybe deter more people than him going to jail. Okay,
so you're saying both the fact that he's done good work in the past is a reason to mitigate the sentence, and we could maybe use the opportunity of the prison sentence to make him do community service, have him go around and teach classes. People might pay attention to someone that famous who's going to teach a class about the dangers of gun violence, so use this to our advantage. Taking a pause from this for a moment, those who would favor a prison sentence, what do you think about this argument that his charitable activities in the past are grounds for mitigation? Are you persuaded that the fact that he's done good work, he's used his wealth for good in the city, warrants a mitigated sentence? Yeah, what do you think?
I think lots of people do, lots of good things, but they make that one mistake. Just because you do charity work and murder someone doesn't mean that you can't go to jail for that.
It can't be a get-out-of-jail-free card, right? Other arguments?
He didn't just make the one mistake. This is the second mistake. So that's the difference to me. It's yes, I understand if it was a first-time offender, people deserve a second chance, but this is his third chance at this point.
Yeah, okay. He's not a first offender. I saw one more hand in the back. Yes.
Also, when he puts on that jersey, he's a representation of that team, which also represents his state and then the country as well. So do we really, although he's doing that charity work, which I don't know if it balances out completely, is that enough to say, because he's not in such a spotlight position, is it okay that he's doing that and it's okay to do that? Is that how Americans should act? Probably not.
Professional athletes from time to time will say, I'm not a role model. But of course they're role models. Kids all over the country look up to professional athletes. And so there's maybe more damage. His conduct is maybe more damaging than some total stranger that kids have never heard of committing the same kind of crime. Other arguments, yes?
I think every case is subjective, so the facts should be taken into account. And the fact that he has done charitable work needs to be looked at, needs to be addressed. So I think that you have to take into account each case's differences. And in this one, he has a past of good deeds, and that needs to be looked at.
Okay, so you're right. He's got a history of charitable contributions, and those kind of good works maybe help to demonstrate he's a person of good character. How would you respond to this argument? If we give a discount to rich people who give their money away, that's unfair to poor defendants who don't have the resources to deliver. So I'll throw that open to everybody. How would you respond to that kind of an argument?
Well, essentially, when you say that he needs to have a harsher punishment because he's in the public eye, it's a disservice to him that people who were poor wouldn't have. Like, you wouldn't have someone who committed this crime who was, not wealthy, not in the spotlight, saying, oh, well, we need to punish him to show the others in his community that they can't do this. But you're essentially doing that to him, so you should take into consideration the opposite, which is he does have money to give away, and he does choose to give it away.
Oh, it's a nice argument. If we're going to use his wealth and high profile as a reason for more punishment, surely we should at least give him credit for the way that he's used that profile in the past. Other kinds of arguments? Yes?
I think community involvement can be considered for all people, regardless of their socioeconomic status. Could even contribute in more ways than just giving money. such as volunteering your time. And I do think it's a positive thing to look at because you don't want to ruin the person's life by sending them to prison, stunt their career. You could just be creating more problems for that person and taking them away as a resource to their community.
Okay, great. These are utilitarian arguments you're making. Now you're talking about the costs and benefits of the criminal punishment. That sending him to prison wrecks his life and does more harm than good. It's better to impose a lesser sentence, maybe no sentence at all, but a probationary sentence that won't disrupt his life, won't take away a valuable resource from the community who's been contributing in a positive way. Other arguments?
I think also my issue with, I was on the side of I wouldn't give him any punishment.
No punishment at all, yeah,
is
why?
that this is an unloaded firearm, which is about as useful for committing violence as the chair it's sitting upon. And it's also in a private space. Like, while yes, there are people that work for this company that have access to the locker room, at the end of the day, it's to the company to decide if they want to punish this employee, if he broke a company code. I mean, this is not someone, like, he couldn't go out and, blast his teammate with this gun. That's not going to happen.
Right.
And I think that it's a little bit of a crossing line. What's the difference between him having this gun in his home or his locker room? They're both private spaces that, he's been given access to by private choices.
Okay, great. Nobody got hurt here. You can't use an unloaded gun to do anything, and it's not as if you left them on the street where just anybody could find them. This just wasn't enough of a danger, not enough of a risk of danger to warrant criminal punishment. Other arguments?
I think to combat that, though, the law is that possessing a firearm, loaded or not, without a license is illegal, and his charitable work aside is uncorrelated to his pattern of criminal behavior with respect to firearms.
That is the law.
Whether or not someone got hurt doesn't matter. The law was broken.
So I guess we can ask the earlier question, should that be the law? Should we be punishing people as criminals for possessing unloaded firearms without a weapon? Should we require a registration for possessing an unloaded firearm at all? The District of Columbia has decided the answer is yes, but we can challenge that, and we do challenge those kinds of questions in law school all the time. Other arguments, and we'll switch to another hypothetical here in a moment, but other arguments.
Sure, I kind of started in the camp of no probation, nothing. Kind of agreeing with Joe and everything. I feel like the administrative burden on the state, like all the resources and personnel used to go after this guy is not really necessary because they were unloaded firearms in a private space. Yes, he has a prior conviction, but it wasn't violent. I think maybe a slap on the hand and the team taking care of it is enough for him to deter him from that in the future, and also saving all of the state's resources and going after more appropriate offenses.
Excellent. Okay, so when we talk about criminal sentencing, broadly, a couple different schools of thought about reasons for criminal punishment. We've articulated some different utilitarian arguments. These are arguments from consequences. Either punishment will do some good by deterring future criminal conduct by the offender or by others, or by contrast, we could talk about retributive reasons, that his blameworthy mental state, the harm he caused, the risk he created, the fact that he's thumbing his nose at authority, those might be reasons to punish him for his blameworthy state of mind or for the harm that he's caused to victims, the risks that he's created. So retributive arguments, some of them, which, regardless of whether it does any good, you might think he deserves to be punished. He's morally deserving of punishment because of the risk that he created to others, because of his blameworthy mental state. By contrast, some of you are making arguments that are consequentialist in nature, that are saying it would do good or would avoid some evil by imposing criminal punishment. Okay, let's look at the second hypothetical. This is another real case. I worked on this case when I was a clerk for a judge in the 10th Circuit. Carl grew up in poverty in Wichita, Kansas. He's raised by a single mom. He was a member of the Junior Boys gang as a youth. He served a long prison sentence, 10 years, for aggravated assault and discharge of a firearm at an occupied building, gun battles with members of rival gangs. After he serves his sentence, he's a different man. He's a changed man. He's converted to Christianity. He's served a long prison sentence. And he's paroled back into his own old neighborhood. He's on supervision for some period of time back in his old neighborhood. And he's not allowed to leave. Many jurisdictions don't allow you to move away from the county or the state where you committed your offense. Back there, he's facing threats of gun violence all the time. His old rivals have scores to settle. He narrowly survives a drive-by shooting at his home, and he's frightened for his own life, so he does something that he knows is illegal. He goes and gets a gun. He acquires a firearm, which he tells the police is only for defensive purposes. He's going to use it in self-defense if it becomes necessary. Police discover that he has this gun when they're responding to a domestic disturbance call at his house. It doesn't have anything to do with him, but they happen to be in the house, and they discover that he has a gun. It's against the law. He's charged with possessing a firearm after being convicted of a felony. The statute, again, allows a judge discretion to impose a sentence of up to 5 years with an advisory guideline sentencing range of 6 months to 2 years. And again, the judge can impose a sentence of probation. Again, show of hands, how many would say no punishment at all? This should not be criminal conduct at all. Only a few of you. How many would say probation only, a sentence of a criminal sentence, but only a sentence of probation? About half. How many would say prison, let's say of up to a year, a custodial sentence of up to 1 year? Maybe about a third of you, okay. And how about more than that? 1 to 5 years of imprisonment. All right, we got at least one person for the maximum, or something close to it both times around. So those of you who would impose a prison sentence, let's hear why. What persuades you that a prison sentence is warranted for Carl? Yes?
He's already committed a felonious offense in the first place. He's serving prison time for this offense, 10 years to be exact. And another situation arising with possession of a firearm, potentially to be used for violent means, deserves to be punished appropriately.
So what is it about the prior offense or the fact that he's possessing a weapon after his prior offense that persuades you he deserves a prison sentence?
The affiliation with the gangs before and the potential for gang affiliation and recidivism after going back to his, I guess we'll call it his place of origin.
He says he's changed. He's a changed man. He doesn't intend to. What's that?
He has a gun in his house.
So you just don't believe him. You're skeptical that he's really changed. So he says his purpose is for self-defense, but you're doubtful that that's his real reason, and he could use it for criminal purposes. In the back, yes.
Well, I have a question. So
Sure.
if you have committed a crime and you served in prison, can you no longer be eligible for a license to carry a firearm?
No, you cannot. So there are federal firearms laws that make it a crime for any felon, anybody convicted of any felony, to possess a firearm, at least for a certain amount of time. So no, he can't get a gun legally. It's either get a gun illegally or not carry a weapon at all. And he says, I'm in danger. They tried to take my life once already. I need this gun to protect myself. That's his argument anyway. Good question. Others?
Well, I was kind of short on this because I feel bad for him. But at the same time, I think if I was Carl and I got caught with a gun, what are all the things that I would say? I would say, I'm reformed. I would say, my life was in danger and that I did it.
You're saying if you were using the gun for sinister purposes, this is exactly the story you would want to tell. So again, reason to doubt the sincerity of his claim that this is a weapon for self-defense. Other arguments, yes?
I think also the potential for escalated violence as a result, especially if he's feeling like he's in danger of carrying a weapon.
Yeah.
Probably be a reason.
Okay, if the risk is that someone's going to take an attempt on your life, carrying or adding one more gun to the mix here is a step in the wrong direction. What we should be doing is, he should be reporting this. He should do something else besides carry a gun himself. All right, great. Other arguments?
I think the way it's written is very sympathetic to Carl.
Yeah. I was pretty sympathetic to Carl. Truth be told.
If you take a step back away from the way it's written, I think the facts are clear that this is a pretty bad case. And if he has a gun, he's a former gang member. I think we had some arguments over here earlier that were along those lines.
All right.
You gotta assume he's probably not doing too well.
There's one more wrinkle here that I'll share in a moment that might make him seem even more sympathetic. But let's argue this case first. In the middle, yes.
It's kind of similar to that. I think that the fact that he intentionally knew he was breaking the law and admitted to that is something to think about when you think about whether or not he deserves sentencing.
Yeah.
Because his reasoning was that he had no choice, but in reality he had a lot of choices. He may just not have pursued those options. For say he could have went and tried to negotiate terms where he could move out of that area. And so the fact that he's knowingly breaking the law, I think deserves punishment, because if you don't punish him, it sets a precedent in the future to where people can act act similarly and not be punished for breaking the law.
Okay, great. A mixture of arguments there. You mentioned at least three things. For one thing, just the fact that he knowingly breaks the law, that seems to strike you as a blameworthy state of mind. Maybe that deserves punishment. That's a retributive argument. You said that we need to send a signal to others that, that you can't break the law knowingly without, and then escape punishment. That would send the wrong signal. That sounds like a utilitarian argument, a deterrence type argument. And you've anticipated, so in the real case, Carl raised the necessity defense. He said, I had no choice but to carry a gun. He said, this was a case where breaking the law by possessing a gun was the lesser evil. I avoided a greater harm, namely an attempt on my life or a gun battle with my former rivals. That would have been a greater evil, and I avoided it through criminal punishment. There's this common law defense, the necessity defense, that he said he was entitled to. And you've anticipated one of the key elements of that offense, which is that the defendant needs to prove they had no lawful alternative. And if the defendant did have some other lawful way of avoiding that evil, then they're expected to do so, and they're not entitled to break the law. And so you're convinced there might be something else you could have done. You negotiate with the parole people. Maybe negotiate with his former gang members, if that's what it takes. Do something, anything, other than carry around a gun. Okay, other arguments.
I feel like one thing we have to definitely take into consideration is his environment. If there was just a drive-by shooting, I'm like highly sure that the police presence in the neighborhood is nil. So how likely is it? And then in a gang situation, going to tell the police just pretty much ensures you're not going to make it home that day. Right. So like I feel like I would say like probation, just because you did knowingly break the law, but understanding the environment and understanding the police presence in that kind of environment and understanding that he probably had a family to protect, he had to protect himself. You could talk to his probation officer, he's a Christian, so maybe he's going to church. You could talk to his pastor and see like if he's really about the reformed life he says he is, because knowing that environment, I know a lot of people who have been to jail and still carry a gun because they're like, I left the gang, but the gang never left me. Right. So if they come at me, I would hate to have to shoot you, but I will. I'll shoot you before you shoot me. So I understand that a little bit better. And I feel like, yes, he broke the law, but you have to take into account the circumstances under which he broke that law.
Excellent. I particularly like the way you're talking about what his alternatives really were. It's easy to say you should have gone to the police, you should have talked to the probation officer about alternatives, but if the police are non-responsive and the probation officer says no, what else do you do as he's in a situation where he's in a great deal of danger? Okay, in the middle, yes?
Yeah, and just building off of that, if he made a choice too, he decided to get a gun instead of violating his parole and leaving, which probably would have been a lot safer option for him in the first place. So that's probably something to consider there too, that he consciously chose to keep himself in that dangerous situation, but kind of did something to make it at least a little bit safer.
Okay, so he had other options like flee. It would have been a different kind of violation. It would have been breaking the law, but not as serious. It wouldn't have been a criminal offense. In the real case, by the way, he really wanted to live with his aunt who lived in another city. That's what he kept asking the probation department to do. But they said no, because they wanted to keep an eye on him, and the local authorities wanted to keep an eye on him, and it ended up getting him in a lot of trouble. Okay, other arguments.
I think going after the guns, going after the wrong problem. There's obviously a horrible gang culture violence here that the police are obviously capable of addressing. I just think that there's only so much the police can do with this underground gang violence, and I think that he had a family to protect, and he took matters into his own hands.
So do you think we should punish possessing a firearm?
I'm for probation, because he did break the law, but at the same time, I'm not sure he had really any alternatives in that culture of gang violence in his area.
Okay, great. So we've switched over to arguments for a probationary sentence, which is great. So let's hear more of those. Yes?
Oh, well, actually, I was thinking no sentence.
Oh, okay. Let's hear no sentence at all then. Sure.
I just feel that because under normal circumstances, the police would have a responsibility and an expectation to protect him from violence, but the police are sort of, at least I'm assuming in this, if this is anything like other gang areas, the police are sort of they're no longer able to maintain normal order, and that because the police don't have the ability to offer him that protection that he is out, that he had a necessity clause that, he's entitled to have that right to safety from being a taxpayer, but the government's not giving him that, so he has other recourse.
the police would never say, yes, we've rolled over and we're no longer protecting people in this neighborhood, but that might be effectively what's going on. There might be violence might be so prevalent in this neighborhood that they can't stop it, or they can't stop at all. And so this is a circumstance where, despite the best efforts of the police, violence is continuing. Other arguments for a probationary sentence. Actually, let me go here. Yes?
I mean, I think it sucks that he's in that environment, but regardless, he still broke the law. I would definitely give him some leniency in a sentencing, but you can't change like the policy of his neighborhood and stuff like that. That's still the law at the end of the day. And it may not be fair given the circumstances, but it's still the law, and you broke that.
Yeah.
So you got to sentence him or give him probation. You just can't, let him off the hook for breaking the law.
Because and it's because it was blameworthy. The decision to break the law is just a moral wrong that he's committed, and it needs a response, a punishment.
As well, too.
Okay, excellent. So I've withheld one critical fact about the real case, which is Carl, in the real case, didn't possess a gun, he possessed body armor, which is registration requirements, and the ban on possessing it is exactly the same. All he did was he got a bulletproof vest that he wore around his neighborhood, and he was prosecuted, and in the real case, he got 10 years in prison for carrying body armor. I know, right? 10 years in prison for carrying body armor, and the theory behind the ban on felons wearing body armor is essentially the one that we heard articulated right off the bat, which is that he's a prior felon, and felons, bank robbers, use body armor all the time so that if they get in a shootout with the police, they're more likely to survive. So you can use body armor for quite dangerous purposes, but Carl said quite plausibly, I just wanted to protect myself. I didn't even possess a gun, and he got a sentence even longer than the one in the hypothetical. Yes?
So, basically, even if you switch body armor and gun, I have the same issue in that, yeah, I get that he's a convicted felon.
Yeah.
But he's still an American rights, and as we're seeing, like, if it's a gun, clearly the gun laws aren't working in this neighborhood because the other guys have them.
Yeah.
And I get that you want to control who has firearms, but whether it's registered or not, these guys have guns. This poor guy is stuck in the neighborhood. Police response times in good neighborhoods are like 8 minutes. If it's a drive-by shooting, police aren't going to be able to help this guy. And to say, that, oh, well, you are a felon, you don't get a gun, you don't get to vote anymore, you don't get to, you're basically saying that you were a felon and we're going to make sure you're always a lower member of society than the rest of us, rather than trying to actually reform this guy. So I have an issue with the law.
Yeah, okay, so you think this is something we shouldn't criminalize at all, or at least that the different kinds of restrictions that end up getting imposed on people convicted of felonies are too severe and end up restricting people's options after they're released from prison. This is a great example of that. I'm going to stop discussion of this case so we can do one more. I've only got another 5 minutes or so. Let's talk about James and Samantha. So these are two 20-year-old defendants. They're addicted to meth, and they need cash to get to keep their habits. So they shoplift from a Kmart. They steal $400 in CDs. This is an older case. They steal $400 worth of CDs, and they make a break for the parking lot. As they're escaping from the parking lot, a private security guard grabs on to the back of the car and doesn't let go. They speed away, and the security guard keeps on holding on and is dragged to his death trying to escape from the parking lot. They're horrified. They didn't want anybody to get hurt. They were just trying to steal some money so that they could sell it for drugs. They have some prior convictions as juveniles, but nothing for a violent crime. They both plead guilty for theft. So let's assume they're guilty of a theft offense for shoplifting some CDs, which would be although this is a felony in the jurisdiction, lots of states have rules about whether it's a felony or misdemeanor depending on how much of the dollar value of the thing that was stolen was. So let's assume $400 trips the tripwire and becomes a felony. And so they're guilty of a felony for theft, but they're also charged with first-degree murder for killing the security guard. Up to life imprisonment, even a death sentence, is authorized for murder in these circumstances. Let's see a show of hands again. So let's assume they're going to be punished for the theft separately. How many would say that for the homicide, a sentence of probation or no sentence at all is appropriate? Only probation, a non-prison sentence. I saw half a hand that then came down really quickly. So not much enthusiasm for that. How about a prison sentence of 5 years or less? Let's go with a short-term prison sentence. About a third of you. Let's say, how about 5 to 20 years of imprisonment? Almost all of you, okay. And how about over 20 years? 20 years to life imprisonment. Anybody for the death penalty? Death to James and Samantha. Nobody. All right. So let's hear first from folks who are on the higher end, who would have proposed a criminal sentence of up to 20 years. Yeah.
I'm not sure I would give James and Samantha the same sentence, but I think that the fact that they were committing a crime, and the fact that it escalated and caused someone's death isn't necessarily abnormal in the situation that they're in. Like a lot of times, if it's not like a planned crime where someone dies, it ends up being an escalation of a situation that they're involved in because they were involved in a crime already happening.
All right, so you've put your finger on the rationale, or at least one of the rationales of the felony murder rule. And that's the reason that James and Samantha can be convicted of murder here. The idea is that if you kill someone in the course of committing a felony, even if it was unintentional killing, even if you did nothing wrong, even if you weren't even negligent in the way that you carried out your crime, if someone dies during the course of a felony, then you're guilty of murder. That's the rule. And the theory is just what you described. You were committing a crime, which is itself kind of blameworthy, and all crimes, or at least dangerous crimes, carry with them this risk of escalation and of death that thus warrants the most severe kind of sanction. First-degree murder, for example, for a felony murder. Okay, other arguments for a more serious punishment. Yes?
Sure. I think you can actually make an argument that this isn't an unintentional death because it was a means to an end. Like, their end was getting away from the crime that they're convicting.
Yeah.
And the means, in this case of them getting away, I mean, they didn't get away with it ultimately, but the means to them getting away was that someone died in the process. So I don't think that's an unintentional death at all. I think they intended to stop him from stopping them, and in the process he died.
And they were willing to do anything it took to get away. Okay, so I like the argument. It's a means to an end. It's a kind of intent to cause that result, even if it wasn't their conscious object. It was something they knew full well was going to happen, and they were willing to hazard it. At some point they should have noticed the guy's holding on and probably being badly hurt, and they kept on driving. Okay, other arguments.
Yeah, and going off of that argument as well, I feel like it would be a little bit different if, let's say, they were carrying guns and they were confronted with the person.
Yeah.
They shot him in the heat of the moment, like, oh, the person's about to stop me, I don't know what else to do, I shoot somebody. But they're clearly driving the car for a long time, long period enough to kill him. So they have the choice to stop. And I think that's what makes a difference in the case. Like, it was intentional to keep on just driving when a person's holding on to the back of the car. And also, I think Samantha and James should get a different type of sentence because Samantha is the one that actually is continuing to drive.
Okay, drawing a distinction between...
Maybe James was like, hey, maybe we should stop.
That's another striking feature of the felony murder rule. It doesn't matter which of the co-defendants or co-conspirators actually caused the death most directly. All of the co-conspirators are on the hook for murder. So if you're the driver while somebody else is in knocking off the liquor store and someone dies in the liquor store while you're sitting there patiently waiting for your friends to get back, you're guilty of murder, having done nothing. It's a striking feature of the rule. But your intuition is the opposite. You think there should be a difference. It's after all, it's Samantha who gunned the gas and.
Both go to jail. I just think that maybe a difference in years, or let's say Samantha goes to the death penalty and James goes flying.
Yeah, okay.
So because she is actually the one driving, she's the one making the choice to just keep on driving.
Okay, excellent. Other arguments, yes?
I think the fact of the case that we're all missing is they're addicted to meth. Like they may potentially be under the influence while they're committing the crime. They have no prior record of homicide or violent crime. They could very well be high at that moment and not understand what they're doing.
Okay, and what is it about that? So if they're addicted to meth, why does that strike you as grounds for mitigation, at least? It sounds like you're saying maybe a prison sentence is warranted, but something on the lower end.
It would give them time to get clean of it. It would show others what happens when you're addicted to it. It would ultimately, prevent potentially further use of the drug, use of crime, any of it.
Okay, great. A bunch of different arguments there all in a row. So arguments from deterrence, either to deter them or to deter others who would see the consequences of using drugs and engaging in committing crimes. And a rehabilitation argument. A prison sentence here is a chance for them to get clean. If they're locked away, at least for a short period of time, we can use the criminal justice system as a way of reforming their lives, making them more productive members of society. And you started with they might be out of their mind. crimes. They might not know exactly what they're doing. Crystal meth is a really wicked, highly addictive drug. And so if they're, at some point they become desperate enough, they're committing this crime, and they're in a sense not themselves. They're doing it because they're in the control of a substance, and so not fully culpable. It's a reason to think that they're less blameworthy from a retributive standpoint. So excellent. I only have time for a couple more comments. Yes?
We have to think of the family of the security guard. I mean, if at the end of the day they get less than 5 years, it'd be the equivalent of if this was manslaughter or an accident. You'd still get some prison time most likely. And that's basically what you're telling the family. So this would be the same as if someone was speeding and hit a pedestrian. That's what we see it as.
Excellent.
And as the family, I don't know if you can handle that.
All right, this is another kind of retributive argument, focused not on the defendant's blameworthiness, but on the harm done to victims. This is a harm that cries out for justice. An innocent man is dead. He was doing his job trying to prevent a crime, and he's dead because of their action. That cries out for justice in itself, that there's a warrant for criminal punishment, and you think 5 years just isn't enough. The taking of an innocent life deserves more than that. That's a retributive argument for criminal punishment. All right, I don't want to take any more time. We've got a civil procedure lesson, but thanks very much. So this is the kind of discussion that you can imagine in a criminal law class in your first year. We go through a whole bunch of different materials on criminal sentencing. Welcome to Indiana. I hope that if any of you want to talk to me about our criminal law and criminal justice programs here at the university, I'd be happy to do so. And I'll turn it over to Professor Quintanilla.
Okay, well, welcome everyone. My name is Professor Victor Quintanilla, and I teach civil procedure, which is in effect the rules for litigation and the system design rules for civil processes. So how we go about filing cases, jurisdiction, and essentially everything from A to Z through the trial. The first thing that I'd like you to do actually is to, since you're going to be working with your neighbors today, I want you to turn to your neighbors on your left and right hand side, introduce yourself, and I have a question for you. So if you were going to go into public service, which branch would you be most inclined to go into? The executive branch, legislative branch, courts, or administrative agencies, and why? So speak with your neighbors about that. Go ahead. Basically that I'm going to teach you I'm going to simplify, and I'm going to teach you some ways to read a case. I'll teach you one of the metaphors that I have, which is the compass and the map, as a way of making through these cases. And we're going to follow the logic of a case and then evaluate some of the decision, the way that the court reached its conclusion. On the way, we're going to learn a little bit of civil procedure as well. So first off, you should have in your materials, I'm hopeful that you have a case, international shoe, yes? Okay, great. So why don't you go ahead and pluck that out. We'll be talking about that case. So first off, a brief introduction. What is personal jurisdiction? Well, I'll tell you. Personal jurisdiction is the power of the court over the defendant and the property at issue. So a court has to have personal jurisdiction to be able to commence and litigate the case. And a little bit of history, the case that you have in your materials is one of the most famous and transformative cases that you're going to read in law school. So we're going to get you started on this a little early then. Before this case, there was a case that controlled the law, which was called Maurer versus Neff, back in 1877. That will be relevant. Let's keep that in mind, 1877. So essentially the view coming out of Maurer was that the states were independent states, independent sovereigns with territorial boundaries. And the prior decision was that under the 14th Amendment Due Process Clause, it would be unconstitutional for a state like Oregon to reach out and require someone in California to come back to Oregon and to defend themselves for having breached a contract in Oregon. So it would be unconstitutional for a state to reach out and require someone outside of the boundaries of the state to come back and defend themselves for harm they committed in that state. And so this view was basically based on, in order to have jurisdiction, someone would have to come into the territory of the state and personally be served in the state, and then you've got them, and then you can commence litigation. Okay, so that was the prior law. International shoe was transformative. And to get you started, I'll give you a little bit of the facts, procedural history, and then we'll move into the compass and the map metaphor. So here, Washington, there's a Washington state agency that seeks to assess fees based on an unemployment compensation fund. So in effect, Washington state, like many other states, has an unemployment compensation fund. Employers doing business in the state have to contribute based on their employees in the state. So the question becomes, who is International Shoe? Well, International Shoe is essentially a corporation that was based out of St. Louis, Missouri, that had sent salespeople into Washington state. What they did there was essentially they would show customers one shoe, all right? Not two shoes, one shoe. Here's a shoe. Are you interested in buying our shoes? And then the customers would say yes, and the salespeople would draft up an offer from the customer, which would then go back to St. Louis, which would be accepted by International Shoe in Missouri. And then they would do this, which is called freight on board. They put the shoes in the mail, and that means we're not the ones who actually sent them back into Washington state. The postman was, and the customers took ownership of it. So they basically said, we're not actually doing business in Washington state, so we don't have to pay into your unemployment fund. Woo-woo. So obviously what happens is Washington state agency then essentially says, so this is the procedural history. How did this come to the Supreme Court? Well, this agency says, hey, you've got half dozen employee salespeople on the ground. We're going to fine you because you haven't paid into the unemployment compensation fund. The agency levies the fund. The corporation says, wait, you don't have jurisdiction over me, no personal jurisdiction. Gets appealed up to the state court system. State court system says, really? No, we have jurisdiction over you. Goes to the Washington Supreme Court. Washington Supreme Court says, yes, we have personal jurisdiction over you. And then International Shoe basically says, I'm going to file a writ of cert to the Supreme Court because I think this is unconstitutional. All right, so let's begin with the compass and the map approach. The first part of the metaphor is the compass. This is one of the lessons that I think is going to save you a great deal of time in law school and is going to help you tremendously as you prepare for your classes. So what is the compass? All right, the compass is identifying what the question presented in the decision is and what the Supreme Court did at the end of the day. What's the bottom line? What's the question and what's the bottom line? And the big clue here, all right, the big clue here No big secrets. If you're looking for the question presented, you jump to the first paragraph of the opinion, all right? You'll find it usually there. And if you're looking for the bottom line, where do you think you find the bottom line? The end of the opinion, all right? So that's the first thing that you do when you read a case. Opening paragraph, closing paragraph, that gets me started. And I'll give you a hint. The next thing you're going to want to do is find out what was here the international issue, the appellant's argument. What were they arguing? Why were they arguing it? That's going to be on page 164. So what I'd like you to do is I'd like you to exercise this compass. You're going to get a sense of what the question is, what the bottom line is, and what is it that international issue was arguing to the Supreme Court. All right? So what I'd like you to do is I'd like you to work with your neighbors on this, and I'm going to give you 5 minutes. First, you got to get your compass, and then we're going to move to the map. 5 minutes. You've got the case. Speak with your neighbors, and we'll reconvene in 5. Go. Yes. Good. Okay. Okay. So let's regroup, and let's begin with what is the question that the court was presented with here. Yes. What's the question? What is the question? Yes.
Isn't it essentially whether or not Washington has personal jurisdiction over international jurisdiction?
That's it. Okay. Under the due process clause. Way to go. All right. Setting up our compass. And what is the outcome, the bottom line? What did the Supreme Court do at the end of the day vis-a-vis the Washington Supreme Court's decision? What happened? Yes.
They established that Washington did have personal jurisdiction because this company had a quote-unquote presence within the state of Washington.
Well, great. So this would be an affirm. So the Washington Supreme Court's decision was affirmed, and we have a sense now of what the question was, what the bottom line was. Let's get a sense of what International Shoe was arguing. What was the argument that International Shoe was making? This was you're looking for the paragraph on 164, beginning with the appellant. How many of you turn to that? Yes. Okay, what's the argument? Yes, what's the argument?
They're saying that they didn't establish enough activities to establish presence in Washington State. So they don't have, that Washington State doesn't have a right to prosecute them.
So remember, under the prior law that existed, Maurer versus Neff, this was heavily driven by this idea of either consent or being present within the territorial boundaries of the state. And here, International Shoe was saying, we weren't present. We were just showing people one shoe. So you get the sense that the Supreme Court said, no. All right, so that's your compass. Now you've got to develop your map, okay? And so this is what I suggest that you do when reading a case. So you've got your compass, then you get your map, and the map is essentially this. The map is, after having a sense of what the question presented is and the bottom line, now you need to know how the court got there. What was the journey to arrive at the bottom line conclusion? So this means you've got to track the reasoning of the court. No big secrets here. Big clue, those of you who are coming from liberal arts, business, political science, really anywhere where you're doing informational or persuasive writing, you look for paragraphs as the unit of construction, and in particular, topic sentences. So even courts write with topic sentences. You can draw on the topic sentences between the question presented to the bottom line conclusion, and that will give you a nice sense of how to cover the terrain. That is your map. You do this before reading the decision all the way through. Why? There's two ways of reading a decision. One way is using your compass and your map and then drilling in, knowing full well where you're going to go. The other way is a bit more like a mystery novel, and you kind of step back and you're like, wow, I can't believe that's how it turned out. That's called ineffective reading, and the first one is called effective reading. So the second one could be fun, but the first one, if you're looking to save time, you use the compass and the map, and then you drill down a second time. All right, so now I'd like to give you a chance to track the reasoning of the court. You know where you're headed, what their bottom line was. How do they get there? And my suggestion to you would be that you would begin with the first paragraph, the last paragraph at the bottom of the page of 164, read that all the way through, and then work through the topic sentences to reach the conclusion. Work with your neighbors, and we'll reconvene. Go. All right, let's go ahead and reconvene then. So this next task essentially was we created our sense of what the conclusion was, what the bottom line is, and now we're in effect tracking the reasoning of the court using the topic sentences, fleshing this out, and this will be our first read of the opinion. And then we will go through and do a more thorough read as we build out our case briefs and prep for classes. But this will give us a good sense of where and how the court reached its decision. So let's open this up to discuss. What did you come up with? What seemed to be some of the persuasive reasoning, some of the principles or rules that the court used to arrive at its decision? What do you think? What do you think? Yes.
So they start off to kind of address the prior precedent, because it would seem that if they're just going to follow precedent, that international shoe companies are going to win. But they say that the rounding in that case and the reason they followed that has now changed. So they say that the way we do cases in civil suit isn't the same anymore. So we're going to kind of wipe away this precedent, and we're going to kind of re-examine what does it mean to have a presence and what does jurisdiction really mean now.
Okay. Next, who else? This is a good place to start. Yes.
And also, like, going off of that, to have a presence, the companies, the individuals that work for the company are now representatives of the company. So that's like how they're changing it a little.
This is one of the difficulties, by the way, with the prior approach, which is based on physical presence. Where is a corporation? Where is a corporation? Well, the only way to kind of get your head wrapped around that and your hands wrapped around that is basically to say the corporation is where the business activity is happening, right? It is where the people on the ground are, where the brick and mortar is, it's where the business is. And so the court was unsatisfied with the prior approach for that reason. So where did we go next? Yeah. Yes.
I think an important part was the continuous flow, or continuous and systematic. So it's like, those two things: continuous and systematic operation of business within the state, make it amenable to be litigated in the state's courts.
Okay, so you get the sense now that we're looking at some kind of contacts. We're looking at minimum contacts that would make it reasonable and fair to exert jurisdiction over an out-of-state business that's conducting business within the state. And the court speaks about this kind of sense that there may be instances where the business is conducting such heavy, continuous, systematic business within the state, but that's certainly going to be fair to say that the corporation needs to defend itself for that reason. When we're looking at that kind of heavy business, surely that must be reasonable. Yes?
Also, I know it was going to say that since they were sending, shooting back, you had the privilege of and protections of the state. So since you have those privileges and protections, you also can be sued because you are enjoying those privileges.
So how many find this kind of reasoning persuasive? This idea. Okay, So here you see, this is one of the major cruxes or linchpins of the rationale. And we were going to turn to this a little later, but we can turn to that now. And you get a sense, and you'll have this sense when you read these cases. You'll pass through, you'll use your compass and your map, and you'll look at the law, and that will be helpful. But you'll get the sense there's sometimes things that are animating, that are ticking behind the curtain, right? That are basically influencing the judges. And that could be, as Professor Scott said, some philosophies about justice. So you get retributive, deterrence, general, specific. These kinds of philosophical notions could be influencing the judges. And sometimes these kind of moral arguments are persuasive. So this is a classic moral argument that you can track through Western civilization to the time of pre-Socratic philosophers. And it's the idea that with benefits come burdens. I like to say this is the old man in Spider-Man. So it's like with power comes responsibility. Okay, so we see that kind of weaving its way within the decision that's animating some of this. So anything else? Yeah. Let's see here. Anything else? Yes.
Maybe I'm not reading this right, but that in the precedent case of Maurer versus Knapp, that it was more of a one-off thing, and that in this case, it continued systematic. So that they have no right to use Maurer versus Knapp as a precedent. Well, not no right, but like less.
So we're basically, what we're seeing is there seemed to be a shift away from Maurer. And it's interesting that you make this point about the context, or the amount of context. We saw from one angle that there was this heavy, continuous, and systematic context that would make it fair. But here, international shoe really didn't have that kind of continuous and systematic activities. There was some other kind of level of contact that was happening that still made it fair. What are we looking at here?
I think you can talk about the fiction versus fact, and how they're saying like you were fictionally, like displaying the one shoe, but as a fact, you are the only people who can sell that shoe. So your presence is a presence without being a presence.
So, and unpacking that, so the contact was salespeople on the ground showing shoes. It's not going to be this heavy, continuous, systematic, millions of dollars of activity, but it's still going to be activity. And what we're trying to do is what we're saying, drawing on the benefits and burdens formula. Listen, you're taking advantage of the benefits of the state. You're conducting limited business in the state. And what we're asking you to do is to defend yourself in the state on the claim that you should be paying into the unemployment compensation fund based on your contacts in the state. That is reasonable and fair minimum contacts. So this is some of the logic of the case. Now, let's see here. We've got one aspect of some of the moral intuitions behind this. And I do want to footnote, we saw political science, we have philosophy, economics, we have sociology, you have history, business. Many of you come from a variety of different disciplines, and all of that knowledge, all of that insight and information is going to be tremendously important to you as you continue, because this will help you understand some of the dynamics behind these cases, right? Or ways of persuading judges based on your insights and backgrounds. So we saw that here. Now what we'd like to do is, let's see if you can begin to identify or evaluate what happened here. It's not that common that we're going to say, to the dustbin goes the old precedent. We don't do that often, but we do it sometimes. So what do you think was animating the decision to say, we're going to take a different tack now from Maurer, and we're going to create this new test, which, by the way, governs today. So 60 years later, this is the test. So I'd like you to speak with your neighbors and see if you can think about what may have been happening in the background, society-wise, that may have influenced this law. Go. All right, so what is happening in the background? What is transpired here? Maurer versus Neff. Yes.
Well, I think right here we have, this is agreed in 1937 and 1940s when I believe the time in question with the salesman was going on. You've got the growth of interstate commerce. Corporations are potentially getting larger. And I don't think it's appropriate to allow corporations doing business in other states to go back and hide in their domicile of origin and say, well, we're doing interstate commerce, but we're going to be protected because we don't have a registered agent in that state, or our corporate entity isn't established in, whatever state it is. And they're trying to hide behind the fact that they're originated in Delaware, their corporate offices in St. Louis, and now they're blameless from any type of repercussion or responsibility. And I don't think that's...
So we do see between 1877 and the 1940s, going into the World War II era, a massive rise in interstate commerce and industry, which really wasn't present. And so you get the sense that this kind of problem wasn't in full view in 1877 in the Reconstruction era after the Civil War. So we see this change. What else? Yeah. Yes.
Are you asking about what was going on to Neff back in 1877, or do you want the...
So let's hear from Neff's perspective then.
Okay, I think that's during Reconstruction, and so you had an aftermath of the Civil War, states' rights was still an issue, we were trying to bring the country back together, and the way that Neff initially was interpreted was that states' rights had autonomy, had a presence there in the state. We also had a huge transition of people throughout the country trying to resettle. People were leaving where they might have had contract. I mean, it would have been a hot mess of trying to track people down to be able to sue them. So for practical reasons, that might have been part of the interpretation, but also just to make people happy.
This is interesting. So you get the sense perhaps during the Reconstruction era that there may be these lingering senses that weren't quite settled after the Civil War about state rights and kind of the sovereignty of state boundaries. And we get the sense that probably fast forwarding into the middle of World War II, that there was a different sense about the relationship between national groupings and clusters. Probably so. What else? Yes.
At this point, there's actually a progression where there used to be stores in a city.
Uh-huh.
Now you're actually having kind of a decentralization of those operations where they're actually satelliting out to other areas, and that's only going to grow as cars become more prevalent, or railroads and everything else. So as everything progresses, the minimum contacts requirements need to progress with it.
Excellent. So we saw this as well, which was if we take the Neff. When I teach this case, I have a picture of a horse-drawn carriage, right, and a steamboat kind of tutting its way up the river. Well, that was pretty much the form of transportation then. And you can think maybe requiring someone in California to travel to Oregon would have been entirely burdensome. You're talking about maybe more than a day, 2 days of travel to defend themselves. Modern communication wasn't as prevalent. We go to the World War II era, we have cars, we have planes, we have rail, we have transportation of goods. It's a very different feel. And one of the things that actually we saw, there's a case that's cited earlier in the decision, Milliken and Maurer. Yes. And what we begin to see is Maurer started to prove itself tremendously unjust in instances where you had people driving automobiles, cars into one state, getting into an accident there, causing major injury, and then driving back home and saying, "Well, we're not going back to Massachusetts, that's for sure." So that proved itself tremendously unworkable. So this is all excellent. Okay, so next, when you're reading these cases, in effect, what we've done is we've got our compass, we have our map, we've stepped behind the decision to think about ways of explaining the decision using the law, and then also either a historical, sociological, economic philosophy, moral intuitions, grounds for explaining. But now we need to criticize the decision. That has to happen as well. So to get you started on this, you can do two things. One is to think about, this would actually support the decision. This would be, what difference, you always have to ask yourself this, what difference does this make if we're changing the rule, if we're changing the law? You have to ask yourself, what difference does it make? What difference would, if we had the prior rule, what would be the outcome? If we have the existing rule now, what is the outcome? And now we can evaluate what difference this makes to parties and litigants. So that's one. And then second, we're going to evaluate and criticize the decision. And sometimes what's helpful is to look at the dissenting or concurring opinions. These are justices that weren't persuaded by the majority view. And so you have one here. You have a form of dissent by Justice Black. And you can go through your topic sentences there to get a sense of what this is. So I'll give you 5 minutes to think about this. What difference does it make? Or evaluate and critique. Go. All right, so let's go ahead and now let's take on our more critical lenses and think both when evaluating the case about what difference it makes. What difference does this rule at the end of the day, the bottom line, make? And then what about forms of criticism of the rule, which you should always be prepared to do and to make when going into class. I guarantee you that your professors will ask you this sometimes with the Socratic method, and so preparing in advance is very, very helpful. So let's think about some of the arguments that one might have about that. So first off, what difference does it make? If we didn't have this rule, how would this have affected the postures of the parties? What would have happened next, do you think? What difference does it make? What difference does it make? Yes.
Well, the fact that they're not held responsible in the state that they're doing business in because they're located somewhere else. So most businesses, I mean, if you're trying to save money, you just set up in one state and then have people in other states.
Excellent. So you got us started, and I commend you for that. So we have the sense that international shoe would not be subject to personal jurisdiction in the Washington state. So what would the Washington state agency that administers the unemployment compensation fund then need to do? What would it need to do under Maurer? Yes.
So they would either need to travel to Missouri or to Delaware, whichever state they could get the International Shoe Company to go to court.
Excellent.
But then on top of that, I would guess that you probably would also need, as the state of Washington, to get Delaware and Missouri to cooperate with you to allow you to sue.
So there might be, so this is interesting. So at the end of the day, as has been pointed out, no suit by Washington state agency in their own courts. It turns out that if Maurer is the rule, you're going to need to go where there is physical presence of the international shoe, and you know you've got that in Delaware where it's incorporated and where it's headquartered in St. Louis, Missouri. And so Washington state agency is going to need to litigate for unemployment compensation funds in one of these two court systems, which strikes you as kind of odd. And this is one of the problems that Justice Black is also dealing with here. But so getting a sense of what difference it makes helps you also intuit why the court may have decided the way it did. Critique, evaluation, critique, leveling critique on the rule. We have the minimum contacts rule. It is where there are minimum contacts and it's reasonable and fair to exert jurisdiction, then you can have personal jurisdiction. You're looking for continuous and systematic contacts, or for there to be a contact tied to the claim in the suit. Criticism. Yes.
The situation I think of is with our current internet and shopping and the way that we do business now, is how would we interpret a law like this where there are lots of contacts from all over the country with companies that are incorporated or headquartered all over the place. And so there ends up being there's complete permeability to the court system where anyone can sue anyone else throughout different places and different locations.
Excellent. So one way of evaluating is to fast forward to the present day and say, how would this work today? What does a contact mean in light of Skype, in light of iPhones, and in light of internet? Interesting. This is going to be difficult. I'm worried. Okay. Other ways of critiquing. Use Justice Black's decision. What is he basically trumpeting and arguing here? Yeah. Yes.
It takes the power away from the Constitution and the states to decide what constitutes fair play, and it gives it to the judge as the arbiter of deciding what it is that constitutes fair play. He feels that that's not right. He's a very strenuous constitutionalist.
We have an institutional argument that basically says that this seems to be an encroachment of authority by judges to decide what's fair and reasonable. I'm worried. The state wins today, but in the future, this might be the basis of striking down the state. Yes?
It also, now whoever sues a corporation has to prove that their activities were continuous and systematic. Whereas Black's critique says that the state should be able to take to court anyone who does business with their citizens.
So it changes he's worried about the default rule. And so now you have this is one form of criticism that you'll see often. You have a very flexible standard, which is in some ways very expansive or contracting. It's difficult to pin down, and you might prefer a more bright line rule. And so that's a form of criticism that you might have for the case. So very, very good. You have done excellently. And so to summarize what we've done today, I've given you a sense about how you can prepare for cases for class. This is the compass and the map approach. And we've learned to follow and track the reasoning of the case, to get behind the case and to think about moral philosophy, political science, sociology, what's happening in the background that may have been persuasive to the judges, and then an initial sense of how to evaluate and criticize the decision. Always look at that dissenting decision and to see if that may hold the ability to evaluate. And you also have had a chance to meet your neighbors and to work with them. And as our dean, Austen Parrish, mentioned, this is important because this is about who we are, right? We work together as a community here. We believe in collaborating with one another. That's a part of who we are. We're based on teams and playing as teams. And the last thing I would say is you bring a wealth of knowledge from many different disciplines, and I encourage you to draw on that in law school when evaluating these cases and thinking about the reasoning. This is going to be important insight for you to share with one another on your journey. Thank you.